Welcome back to the channel. Today's case is one of the most emotionally complex and legally puzzling courtroom moments you'll ever witness. It begins with a deadly Christmas Eve crash involving not one, not two, but 4 vehicles. And at the center of it all is a 9-month pregnant defendant, allegedly intoxicated behind the wheel. The crash left another woman dead, a family devastated, and a court system wrestling with one of the most frustrating legal barriers. Causation. What makes this case so gripping isn't just the tragedy, it's the clash between law, morality, and accountability. You'll hear a judge who's not just angry, but genuinely heartbroken. You'll see a prosecutor trying to justify a controversial plea deal, and you'll watch a defense attorney argue that this crash was unavoidable. Even though the defendant admitted to drinking twisted teas, smoking marijuana, and having cocaine in her system, the emotional stakes explode. When the judge delivers one of the most intense lines you'll ever hear, while you're about to give life, "You took someone else's life." The entire courtroom freezes, and trust me, the tension only builds from there. So sit tight as we break down every twist, every contradiction, and every legal explanation. Because by the end of this video, you'll be asking yourself, was justice served? Or was this a failure of the system?
Supplemental report says that someone in his vehicle
Right, and he was, hang on.
has an extensive history of head injuries, nerve pain, and he was suffering from a pre-existing condition, and all of which have been getting worse since the crash. So that was a person in his vehicle. The people in the other vehicle weren't doing too great either. This car flipped over. There were 3 people in it, may or may not have been drunk. They hit another car.
Judge, that helped me. Thank you.
All right.
Well, what I was gonna say was this. Mason was in Kalamazoo at a Halloween party, was not planning on driving home that night, was gonna stay. He gave a couple other people a ride up there. While they were up there, he drank, and he drank more than he should have, at least certainly to drive a vehicle. But the drinking was up there, and one of his
The details of this crash set the tone for the entire case.
The
The officers describe severe, almost catastrophic damage, head-on impact for one car, a T-bone for another, and multiple vehicles forced into a chain collision. This isn't a minor fender bender. It's the kind of crash that generally aligns with high speed, zero visibility, or impaired reaction time, and based on what follows, impaired reaction time becomes a central issue. Whenever massive vehicular damage is involved, investigators look for the most likely contributors: speed, intoxication, mechanical failure, or unpredictability on the roadway. Here, the officers immediately notice indicators pointing toward impairment: the unopened beer can, the smell of alcohol, glassy eyes, and later, an admission of multiple This moment sets the foundation for what the judge later questions. If all these signs existed, then why isn't this a manslaughter case?
police. So if there's more injuries involved than that, he's never been notified by any insurance company or attorney representing an injured party. So we simply present to you, we're not aware of anybody seriously injured. We are aware that the occupant, his occupant, asked for an ambulance ride to the hospital, was treated and released, and we understood that was the end of that. Now, I don't know whether that enlightens you or adds more questions. But what I would say is this: when you mentioned one other case a while ago being more serious, his came to mind. I talked to him a little bit about it. When I just heard this prior case, I assume that's the one you were referencing, where there's a bad accident and bad injuries and etc. All I can say is in his case, he's not aware of any injuries other than to the one occupant, ambulanced and treated and released. Now, again, be that as it may, I would point out maybe the redeeming factors here is he did not flee and elude the police. He didn't get into a resisting.
Now it's not just a DWI, it's a tragedy with irreversible consequences. This is where courts become especially cautious. A death elevates public interest, judicial scrutiny, and moral weight. From a legal standpoint, the death itself doesn't automatically make this intoxication manslaughter. The prosecution must prove a direct link between intoxication and the fatal outcome. However, from a human standpoint, it's almost impossible not to see the defendant's behavior, alcohol, marijuana, cocaine, and wonder whether this crash could have been prevented entirely. This tension between legal limitations and moral responsibility is what fuels the judge's anger later.
He went to the hospital to have his head checked. He stated no head scan was done, but his blood sugar was checked. He has an extensive history with head injuries, nerve pain stemming from his neck to his arm. He advised the issue with his neck has gotten worse. And bear in mind, this was February after the October accident. And he now has trouble rotating his head due to his neck pain. He has suffered from pre-existing conditions such as short-term memory loss, chronic headaches, light sensitivity, all of which has gotten worse since getting in the crash. As far as I'm concerned, that's operating while intoxicated, causing a serious or debilitating injury.
This part is devastating. The defendant openly admits to consuming 4 to 5 twisted teas, smoking marijuana, and even drinking inside the car. In most cases, this admission alone destroys any defense argument focused on responsible behavior. But the real issue here is credibility. Anytime a defendant admits to multiple substances, but their legal team argues unavoidable accident, it creates a serious disconnect for the audience and the court. Even if legally the causation cannot be proven, morally, the behavior is hard to reconcile. It also raises serious questions. Should the law allow someone with multiple intoxicants in their system to avoid manslaughter charges simply because of causation technicalities? That's exactly why this judge becomes so
bad accident, and then they would never, passenger was removed by ambulance, and they never checked to see what happened to the person. Then you find out they've got terrible debilitating injuries, and this happened multiple times in the last several years. So I didn't know if that's what this was. So it happened in October. They asked for further investigation. That has Ms. Davis's fingerprints on it. She took office in December, and this would have been a case that she would have inherited from the previous administration. So she or somebody, Mr. Gabry or her, asked the police to do some more investigation, which they did. Then several months later, Ms. Camfield authorized this. It also appears that
Here we get the critical scientific evidence, a 0.025 back, plus marijuana and cocaine in her system. Now, the back number might seem low, far below the legal limit, but the presence of multiple substances mixed together can impair judgment, reaction time, and coordination far beyond what back alone reflects. The prosecution clearly faces an uphill battle, proving that this impairment directly caused the fatal crash. And that's why you see a plea deal instead of an upgraded charge. The court must work within what can be proven, not what seems morally obvious. This is one of those rare cases where scientific thresholds and legal burdens create a frustrating gap between public expectation and fair prosecution.
Several months later, Ms. Camfield authorized this. It also appears that that witness and his parents were not particularly cooperative with the prosecutor. But it is a situation where he crashed into somebody else's car, rolled his car over with 2 people in it, and could have killed 5 people. And his blood alcohol was over the high limit for high blood alcohol level. He also has some prior criminal history, and he's only 22 years old. So with that, maybe we'll get enlightened more from the prosecutor, but reading the police report, this looked like a 5-year felony instead of a 93-day misdemeanor, but the prosecutor has the discretion to
This is the turning point, the moment where the judge's shock becomes visible. A 7-day jail sentence in a case involving a death feels wildly insufficient to him, and his reaction is exactly what most viewers feel: disbelief. In the criminal justice system, plea deals often aim to resolve cases quickly and avoid trials, especially when evidence is complicated. But judges also serve as the moral compass of the courtroom, and here the judge firmly rejects the idea that a single week in jail is acceptable when a life was lost. His frustration isn't just at the lawyers, it's at a system that creates outcomes that don't match the gravity of human
Your
loss.
Honor, what I can
Asterisk.
tell you, I think we were in the midst of changing our computer storage systems for these cases, and I now see supplemental reports that the court is referring to that were not available to me at the time of charging, or I very likely would have charged this at the felony level. That being said, it was a serious matter. There were apparently, for that passenger that was injured, pre-existing conditions that may have been made worse, and that would be perhaps one of the difficult things to differentiate at trial as to what was pre-existing and what was the actual injury from the accident, although you do somewhat take your victim as you find them if you make a condition worse. I do think that a period of probation with the victim impact panel and alcohol monitoring is
This is one of the most emotionally charged moments in the entire hearing. When the judge says, while you're about to give life, you took someone else's life, it hits like a thunderbolt. This isn't legal rhetoric. It's raw, painful truth. Judges rarely frame things this personally, but the weight of the situation demands it. He's not just sentencing her, he's confronting her. This moment forces the defendant to face the reality that while she prepares to welcome a new life, another family is mourning a permanent loss. It's the kind of moment that makes you pause, reflect, and question how one split second on the road can change so many lives forever.
Controlled substance use, which is also concerning. I frankly think that because of the severity of the injury and the fact that it wasn't charged as a felony, this is another instance in which 30 days of jail would be appropriate in addition to the community service that's recommended. I mean, there has to be more than an overnight while you're intoxicated wake-up call in these types of instances. It could have, we just had a serious accident on 131 southbound in Kent County or Allegan County, I guess a little bit further south, where 4 people died. And obviously in these accidents that can occur, particularly if a vehicle flips. So I do think that the jail is warranted if we've overcome the presumption of fines and costs in this particular matter. And I would ask that the remainder of the recommendation of Mr. Frazine be followed.
The prosecutor's tone shifts when the judge pushes back. Suddenly, it's clear the original offer cannot stand, and they'll need to craft a more serious consequence. This is where the balance of power becomes visible. Prosecutors propose, but judges decide what is morally and legally acceptable. This scene also illustrates a broader issue in DWI fatality cases. Prosecutors often struggle between legal limitations and community expectations. Even if they can't prove causation, the optics of a lenient plea deal in a fatal case are terrible. This is why the judge forces the conversation back to accountability, fairness, and
obviously
public trust.
in these accidents that can occur, particularly if a vehicle flips. So I do think that the jail is warranted if we've overcome the presumption of fines and costs in this particular matter. And I would ask that the remainder of the recommendation of Mr. Frazine be followed.
Daniel, what's your thought?
Well, I was very concerned about, obviously, anytime you rear end someone when you're drinking is bad. Then, as near as I could tell, and from the information that I have, they couldn't really determine whether what was caused from this accident, what was predetermined. There's bad blood between both parties. One says it's his alcohol, one says it's not. One says they're both say they're not each other's friends. So it's bad blood going back and forth, which fuels stuff. And obviously, you get an accident like this, that would cause you to be upset, obviously. So, and I think part of it is we do get kind of desensitized after a while. You think, well, it's not a felony. I mean, 173 is high, but we're so used to getting so many high ones now.
The defense attorney's argument introduces a surprising twist. He claims the crash was unavoidable because the other vehicle spun out. What makes this moment even more impactful is his background, a former police lieutenant with accident reconstruction experience. That gives his argument unusual credibility. However, his explanation also carries an uncomfortable implication. Even though she was intoxicated by multiple substances, her impairment allegedly didn't cause the crash. This is hard for the average person to accept, and the judge seems to struggle with it too. It's a textbook example of how criminal law often hinges not on moral blame, but on provable causation, a
Pearson or
distinction
whatever
many
his name
viewers
is, he
find
told me
frustrating.
that he was released the same night. He was beat up by the police 2 years prior because he had fled and eluded and done this and that, which is what caused the nerve damage. That's what caused the nerve damage. I was never told that he was more injured or anything from that. I truly believe he's just doing this to try to get me in trouble because he's upset with me.
All right, I can tell that you're not very remorseful, you dope. He didn't try to get you in trouble. They reached out to him and he was uncooperative with them. You crashed your car with a .173 blood alcohol. You rear-ended another car and almost killed 2 people.
Sir, I understand.
Here, the judge wrestles with an ethical dilemma. Is it cruel to make a pregnant woman give birth in jail? Or is it cruel to overlook the death of another person? This is one of those rare courtroom moments where you see a judge think out loud, weighing compassion against accountability. His frustration isn't with the defendant alone. It's with the limits of the law. He can't elevate the charge without proof, but he also can't ignore the tragedy. What makes this moment so gripping is the raw honesty of the judge's conflict. You can feel that he wants to do what's fair, but fairness is complicated when 2 lives, one lost, one soon to be born,
2
hang in the
times the
balance.
legal limit. It took a year or about for you to get arrested on this. In February, the new prosecutor inherited it, asked for more information, which we didn't completely get. We didn't check with him either, apparently. The affidavit says he advised of lasting effects from the head injury. And then there was the follow-up, and then the follow-up got lost in the shuffle or something. So what I said is I feel like I'm in the wrong universe. We had the young boy from El Salvador, who's a 2-something, crashes his car, leaves the scene of the accident, runs a stop sign, fights with the cops. The next man.
This section is chilling because the judge goes beyond legal consequences and speaks about lifelong consequences. He warns that if she used substances during pregnancy, she may face a future filled with caring for a child with developmental challenges, a punishment that extends far beyond probation or jail time. His message is clear. Consequences don't always end at sentencing. This commentary reflects the reality that personal responsibility doesn't stop when the courtroom closes. These moments show how judges often must step outside strict legal roles and address the human realities defendants will face long after the case is over.
Office. Once you got arrested, you've been cooperative. But this ain't a 1 day in jail credit, 1 day. Unless I might as well retire and go tend roses or something. So I'm not sure what is the right answer. You're 22, 23, but you do what 23-year-olds do. The young boy from El Salvador went out and got drunk and then drove his car. It's like, well, of course. You drink way too much at a party, and then when you get to that point, you lose your judgment. It's like, well, I can drive. You had to drive all the way from Kalamazoo to where you were, where you finally crashed into the back end of this other car. We've had a terrible year of accidents on 131. Ms. Camfield just remarked to the one that happened in Allegan County within the last 14 days where 4 people were killed. This guy isn't going out of his way to get you in trouble. What it says, as far as I can tell, nobody ever got his.
Now we move into the structure of accountability. The judge lays out strict probation conditions: no alcohol, numbered drugs, random tests, interlock devices, counseling, community service, and makes it clear he will be personally monitoring the defendant. This isn't typical. Judges don't usually take such a hands-on role unless they feel the case requires extra oversight. It shows just how seriously he takes both the tragedy and the defendant's future risk. When a judge warns that any violation will result in jail time,
But
it sets a tone. This probation isn't a break, it's her last chance.
As far as I can tell, nobody ever got his hospital information. Prosecutor requested additional information from passenger Kirsten Richards regarding current medical condition, and all passengers from both vehicles need to be interviewed. That's either Mr. Gabriel or Ms. Davis in January, right after they took office, saying, hey, this case needs some more work. Kudos to them. In February, contacted Kirsten's parents to receive call from him concerning his medical status. Parents seemed to be uncooperative. Contacted parents of subject taken to hospital after crash. Interview a subject requested by the prosecutor's office. So they wanted to know what the guy had to say. And he says it's all gotten worse since the crash. But it wasn't like he was like, hey, please interview me. Now, who's this? Anything else that you want to tell me?
Not much, sir.
Are you working somewhere now?
Yes, sir.
All right, where is that?
I'm working for my father doing home repair and
All right, that's what he said. You do drywall?
I do everything really, that's for sure.
Well, you're gonna lose your driver's license as a result of this. There's nothing I can do about it.
I understand that.
But I agree, a probation is needed here. I'm gonna do a 24-month probation, which can be discharged at the end of 12 months. I'm gonna order 11 days, credit 1, leaving 10 days to serve, which will be served on the weekends. I'm supposed to do these sentences proportionally. And according to the Auburn Hills Court of Appeals case, I'm not exactly even sure what that means. It is your first drinking driving offense, and it did in fact not get charged as a felony. In fact, they even reduced it from high BAC. So it's just a regular OUIL first offense. There's $300 fine, $75 crime victims' rights fee, $50 state minimum fee, $100 screening fee. You hired your own attorney. $960 probation oversight fee. Ms. Campfield, do you have a police reimbursement in your file?
I'm not seeing one, Your Honor, but it would be to Michigan State Police for a blood test and an accident.
The other one I just did $200.
Mm-hmm.
Drinking driving is an expensive proposition, Mr. Schuster. There's a commercial that says that, and it certainly is true.
What a case. After all the emotion, tragedy, and legal conflict, the defendant ultimately pleads guilty and receives 18 months probation with 30 days of jail time. To many, the sentence may feel light given the loss of life. But legally, without provable causation, the court's hands were tied. This case reflects the painful truth that justice isn't always aligned with emotion. Sometimes the law can only punish what it can prove, not what it suspects. The judge's heartfelt warnings, the prosecutor's uneasy explanations, and the defense's technical argument all highlight the tension between legal reality and moral outrage. So now we ask you, do you think justice was served in this case? Or does this outcome reveal deeper problems in the legal system? Drop your thoughts below. And if you found this breakdown powerful, informative, or eye-opening, make sure to like, share, and subscribe for more real courtroom analyses that pull back the curtain on the justice system.